Excuse me,
I live here.
I live here.
The homeowner reported someone's trespassing.
I am the homeowner. This is my house.
The caller said the owner is an elderly white woman. You don't exactly fit that description, do you?
The caller is wrong. I'm Dr. Simone Hartley. I've lived here 12 years.
The doorbell camera activates before the knock finishes. A fixed frame captures a uniformed officer standing inches from a private front door. It is late. The hallway is quiet. According to the footage, there is no emergency announcement, no request for consent, and no statement of a warrant. The officer knocks again harder, this time then waits, as if compliance is assumed. Inside the apartment is a woman who, based on employment records later referenced in court filings, works as a social worker. At this moment, none of that matters to the officer outside. What matters is the setting: a closed door, a private residence, and a constitutional boundary that has not been crossed yet. The dramatic irony is immediate. The camera is already recording what the officer appears not to consider. Every word, every pause, every escalation. There will be no dispute later about timing or tone. The record is forming in real time. What the footage does not show, but what official filings later establish, is the nature of the woman behind the door. Her professional role has required enforcing legal limits on authority, documenting procedural violations, and operating within strict statutory frameworks designed to protect vulnerable individuals. In her work, consent is not assumed, it is verified. Boundaries are not suggestions, they are requirements. None of this is announced. None of it is leveraged. The authority reversal here is not a title revealed. It is a history of lawful action colliding silently with unlawful pressure. The officer remains at the door. According to the recording, he raises his voice. He issues a warning without articulating a legal basis. This is the first clear decision point. He could disengage. He could clarify the purpose of the contact. He does neither. Each second adds weight. The longer the officer stays, the harder it becomes to argue that this is a brief or consensual encounter. At the threshold of a home, time itself becomes evidence. Courts later reviewing similar incidents have treated duration as a factor that transforms requests into coercion. The camera captures a subtle shift in posture. The officer stands closer. His stance changes. The implication is no longer inquiry. It is expectation. Compliance without consent. Authority without explanation. This is where the trajectory locks. What begins as a knock is becoming something else. A test of boundaries. A series of choices narrowing the officer's legal exit routes. The woman behind the door does not escalate. She does not provoke. She does not open the door. She insists only on process. At this moment, nothing irreversible has happened yet. No entry, no arrest, no force. But the foundation for all of it is being laid decision by decision under a camera that will later be reviewed frame by frame. Months from now, court documents will attach a monetary figure to what is happening here. A number large enough to force institutional review and public accountability. But at this point, that outcome is invisible. There is only a door, a camera, and an officer who has not stepped back. When the door remains closed, the officer's position becomes legally exposed. According to the footage, there is still no announcement of a warrant, no statement of probable cause, no indication of an emergency requiring immediate entry. The threshold of the home remains intact. And under established Fourth Amendment doctrine, that boundary carries the highest level of constitutional protection. Inside the residence is a social worker who, based on employment records later referenced in court filings, was lawfully present in her own home at the time of the encounter. There is no dispute on this point. She is not subject to parole conditions. She is not named in an arrest warrant. She is not the subject of an active criminal investigation disclosed on camera. The legal status is simple and uncontested. This is where the legitimacy gap begins. From the officer's perspective, as reflected in his tone and positioning captured by the doorbell camera, the situation appears to be framed as one requiring compliance. His language assumes authority rather than requesting consent. But the law does not recognize assumptions. At a private residence, authority must be articulated, justified, and limited. None of those elements are visible in the footage. The social worker speaks from behind the door. Her words, according to the recording, are measured. She asks for clarification. She does not open the door. This is not obstruction. It is the exercise of a constitutional right. Courts have repeatedly affirmed that refusal to open a door, absent a warrant, or exigent circumstances is lawful conduct. The camera captures this refusal without resistance, without raised voice, without provocation. Another decision point passes. The officer could disengage. He could verify information remotely. He could consult a supervisor before escalating. According to later investigative summaries, none of those options are taken at this stage. Instead, the officer continues to apply pressure, framing the interaction as mandatory rather than voluntary. The legitimacy gap widens. What the officer appears to misunderstand or disregards is that the woman behind the door is professionally trained to recognize improper assertions of authority. Her work history, later introduced into evidence, shows repeated involvement in cases where consent, lawful entry, and due process were central issues. She has navigated statutory frameworks governing state intervention into private lives. She has documented instances where authority exceeded its legal scope. That background does not grant her immunity. It does something more consequential. It means she recognizes the moment when the law is being tested. The camera records the exchange without editorializing. No sudden movement, no emergency tone, no call for backup related to safety. Just repeated attempts to compel engagement without a stated legal basis. Each attempt strengthens the record against the officer's position. Under Fourth Amendment analysis, reasonableness is assessed based on what a reasonable officer would do under the same circumstances. Here, the circumstances are static. The door remains closed. The resident remains calm. The environment presents no visible threat. As time passes, the justification for continued presence diminishes rather than increases. This creates another silent inflection point. The longer the officer remains, the more difficult it becomes to argue that the encounter was brief, consensual, or precautionary. Duration itself becomes evidence. The social worker's legitimacy is not built through dramatic action. It is built through restraint, through adherence to lawful boundaries, through refusal to escalate. The footage later reviewed by investigators reflects this imbalance clearly. One party attempting to enforce authority, the other simply insisting on legal process. By the end of this phase, the positions are set. One side is anchored in constitutional protection. The other is operating without a clearly articulated justification. The law does not favor ambiguity at the doorstep of a private home. The officer is still there. The door is still closed. And the legal consequences are beginning to take shape, even if no one on the porch acknowledges them yet. To understand why the encounter continues despite its growing legal instability, the analysis has to widen beyond the porch. According to internal records later reviewed during the investigation, the officer was operating within a departmental framework that emphasized control, command, presence, and rapid compliance. These principles are not unlawful on their own. They become problematic when applied without recalibration to context. The footage does not capture internal policy manuals or training briefings. It does, however, capture the behavioral outputs of those systems. The officer's stance remains square to the door. His voice projects certainty rather than inquiry. There is no audible attempt to de-escalate or to reframe the encounter as voluntary. This suggests a default operating mode. Maintain pressure until compliance is achieved. This is not an accusation of intent. It is an observation of pattern. Departments train officers to assert control in unpredictable environments. Traffic stops, domestic disputes, active scenes with multiple variables. But the threshold of a private home at midnight, absent exigency, is not one of those environments. The law demands a different posture. According to later supervisory assessments, that adjustment does not occur here. Another decision point passes. The officer could pause the encounter to seek guidance. Body-worn camera protocols in many jurisdictions explicitly permit supervisory consultation when legal authority is unclear. There is no indication from the footage or subsequent reports that such consultation is requested at this stage. Instead, the officer continues alone, compounding personal discretion with institutional authority. The department's role becomes relevant not because of what it ordered, but because of what it permitted. Training records later cited in civil filings show an emphasis on officer safety and command presence, with comparatively limited scenario-based instruction on doorstep encounters without warrants. This context does not excuse the conduct. It explains how the conduct persists. The language used by the officer remains procedural rather than reactive. He does not shout commands associated with imminent arrest. He does not withdraw. He occupies an in-between space that is legally precarious, too assertive to be consensual, too unsupported to be lawful. This ambiguity is where departmental exposure begins. Each minute adds weight. Each repeated knock reinforces the impression of compulsion. Courts later examining the footage will note this progression carefully, not because of any single sentence, but because of cumulative pressure. Control is being asserted without a legal anchor. The department's internal review will later focus on this phase. According to official summaries, investigators identify the absence of clear articulation as a critical failure point. No warrant stated. No exigent circumstance identified. No lawful directive communicated. The officer is operating on assumption, not authorization. This moment matters because it bridges individual action and systemic responsibility. The longer the encounter continues under these conditions, the harder it becomes to isolate fault to a single misjudgment. Patterns begin to emerge: training gaps, supervisory distance, cultural reinforcement of hold the line. The door remains closed. The officer remains present, and the department, though not physically visible on the porch, is now part of the record being built by the camera. By this stage, the encounter has passed the point where it can reasonably be characterized as casual or voluntary. According to the doorbell footage, the officer's presence has not produced new information, resolved a complaint, or identified a lawful basis for further action. What it has produced is escalation through persistence. The officer knocks again. The sound is sharper this time. His body shifts closer to the door. The camera captures the change in posture clearly. This is another decision point. He could disengage. He could reset the interaction. He does neither. At the threshold of a private residence, escalation is not measured by physical force alone. It is measured by pressure, duration, tone. The implication that non-compliance will lead to consequences, even when those consequences are not legally defined. According to constitutional standards, later referenced in civil filings, this is where encounters begin to resemble seizures without formal restraint. The social worker responds again from inside. Her voice remains controlled. She does not open the door. She asks, once more, for the legal basis of the officer's presence. This is not defiance. It is a request for articulation. The law favors articulation. The footage records that none is provided. Another opportunity to stop passes. Instead of clarifying, the officer reframes. According to the audio, he warns of further action, without specifying what that action would be or what law would justify it. This is a critical escalation point. Vague threats carry legal consequences because they transform a request into coercion. Courts later reviewing similar encounters have noted that ambiguity at the doorstep cuts against the government, not the resident. Time continues to accumulate. The camera clock advances. Each minute makes it harder to argue that the officer's continued presence is incidental. Investigators will later note that there is no visible attempt to de-escalate, no effort to confirm identity through lawful channels, no retreat to a position of neutrality. Control is being asserted for its own sake. This is where constitutional analysis tightens. Without a warrant, an officer's authority at a home depends on consent or exigency. According to the footage, there is no consent, there is no emergency. The officer's continued knocking and warnings narrow the justification window rather than expanding it. The imbalance becomes apparent even without commentary. One side is stationary, protected by the law's strongest barrier. The other is mobile, armed with state authority, but lacking legal footing. The power dynamic is inverted by the setting itself. Then, briefly, there is a pause. The officer stops knocking. He stands still. The camera captures several seconds of silence. No movement, no speech. Just the quiet of the porch and the hum of the night. It is a moment where the encounter could end, where disengagement would restore legality. It does not. The officer resumes, now more insistent. This choice seals the trajectory of the incident. From this point forward, every action will be evaluated not as uncertainty, but as continuation. The law treats continuation differently. It assumes knowledge. It assumes deliberation. By the end of this phase, the legal position is no longer ambiguous. The officer has remained long enough, pressed hard enough, and warned broadly enough that the encounter will later be scrutinized as an unlawful attempt to compel engagement at a private home. The camera has captured it all, not as a single dramatic act, but as a series of small decisions that, stacked together, remove any safe exit. The investigation begins with the footage, because it has to. According to official filings later referenced in the civil case, the doorbell camera recording becomes the central piece of evidence reviewed by supervisors and internal investigators. It is not edited. It is not summarized. It is watched in full. From the first knock to the final moment the officer leaves the porch. The reason is simple. The camera does not argue back. The timeline is reconstructed minute by minute. Arrival time, first knock, verbal exchanges, periods of silence. Each segment is logged. Each pause matters. Investigators do not need to infer intent. They examine conduct. The footage shows no emergency developing, no new information surfacing, no legal basis articulated as time passes. This is where the power dynamic shifts. There is a moment in the recording later described in review notes when nothing happens. The officer stands still. The porch light remains unchanged. The door stays closed. For several seconds, the encounter exists without motion. No commands, no responses. Just presence. No analysis is added. No narration is needed. The silence does the work. When the officer resumes knocking after that pause, the footage takes on a different weight. Investigators later note that the continuation after silence undermines any claim of confusion or rapid decision-making. The camera records deliberation, time to stop, time to reconsider, time that was not used. Supervisory review follows a standard sequence. According to internal procedures outlined in the record, the footage is escalated from immediate supervisors to internal affairs. Each level reviews the same material. Each level reaches the same factual conclusions about what is visible and what is absent. There is no warrant shown, no exigent circumstance identified, no consent given. The audio is analyzed alongside the video. Tone is noted. Language is transcribed. Warnings are examined for legal specificity. Investigators later confirmed that no statutory authority is cited during the encounter. This omission becomes central. The department's position begins to narrow. Internal summaries reflect a shift from incident review to liability assessment. According to later disclosures, city legal staff are notified once it becomes clear that the footage presents a sustained constitutional issue rather than an isolated miscommunication. At this stage, the question is no longer whether policy was followed. It is whether the city can defend what the camera shows. The social worker's professional background re-enters the analysis here, not as a shield, but as context. Her responses are measured. Her refusal to open the door is consistent. There is no provocation on the recording. This consistency strengthens the evidentiary imbalance. The investigation does not rely on memory. It relies on pixels and sound waves. Every claim made after the fact must pass through what the camera captured in real time. Investigators later note that the footage leaves little room for reinterpretation. By the time the internal review concludes, the direction of the case is set. The evidence has done what testimony often cannot. It has fixed the narrative. What began as a knock at a door is now a documented sequence of constitutional exposure. The file moves forward. The consequences, no longer hypothetical, are about to become formal. The legal consequences unfold in stages, not all at once. According to court records later made public, the first response comes internally. Supervisory findings are finalized. Internal Affairs completes its review. The conclusions do not rely on interpretation. They rely on the footage, the absence of a warrant, the absence of exigent circumstances, the sustained pressure at a private residence. These elements are documented, time-stamped, and uncontested. From there, the matter moves to the city's legal department. This transition marks a critical shift. What had been a question of policy compliance becomes a question of civil liability. City attorneys review the same doorbell recording. They assess it under established Fourth Amendment standards governing unlawful entry, coercive encounters, and unreasonable seizures. According to filings, the footage is treated as a worst-case exhibit, clear, continuous, and difficult to contextualize favorably. The officer's options narrow further. Employment actions follow. While specific disciplinary timelines are not fully disclosed in public records, official statements later confirm that the officer's conduct is found to be inconsistent with departmental standards. The department's exposure is no longer theoretical. It is financial. The civil lawsuit is filed. The complaint alleges constitutional violations arising from the encounter at the door. It references the video repeatedly. Each allegation is anchored to a moment on the footage. The legal theory is straightforward. A state actor applied coercive authority at a private home without lawful justification. The damages claimed reflect not only the incident itself, but the broader implications of constitutional intrusion. As the case progresses, settlement discussions begin. According to court-approved documents, the city ultimately agrees to a monetary settlement totaling $4.2 million. The figure is not explained through narrative flourish. It is explained through risk assessment, the likelihood of prevailing at trial, the strength of the video evidence, the potential for punitive findings, the cost of prolonged litigation. The number becomes the outcome. No jury verdict is required to establish accountability. The settlement, entered into the public record, reflects the city's calculation that the footage would be decisive if shown in court. The officer's conduct, as captured on camera, has crossed from internal concern to constitutional liability. For the officer, the consequences are permanent. Career impact follows legal resolution. While certain employment details remain not publicly disclosed in official records, the case becomes part of the department's history. Training materials are revised. Legal advisories are circulated. The video is referenced as an example of what cannot be defended. What is notable is what the resolution does not include. There is no dispute over what happened. There is no competing narrative supported by evidence. The camera has already spoken. The lawsuit does not turn on emotion. It turns on law, timing, and documented conduct. A knock that became pressure, pressure that became coercion, coercion that became liability. By the time the settlement is finalized, the incident has been reduced to a set of conclusions that are difficult to escape. The encounter at the door has been priced, and the price is substantial. The case does not end with the settlement check. According to post-resolution disclosures and departmental communications referenced in oversight reports, the incident triggers a broader institutional response. The reason is not symbolic. It is practical. A $4.2 million settlement tied to a doorbell camera encounter forces review at levels beyond the individual officer. Policy updates follow. Training modules addressing residential encounters are revised to emphasize threshold doctrine, consent standards, and disengagement protocols. Supervisors are instructed to intervene earlier when officers operate without clearly articulated legal authority. These changes are not framed as admissions. They are framed as risk mitigation. Oversight bodies take note. The footage is incorporated into internal case studies, not because it is dramatic, but because it is ordinary. No chase, no weapon, no emergency. Just an officer at a door, staying too long. Oversight reviewers later describe this ordinariness as the most consequential aspect. It demonstrates how constitutional violations can emerge from routine decisions rather than extreme situations. For the department, the incident becomes a reference point. Legal advisories circulated after the settlement highlight the importance of articulation and withdrawal when authority is unclear. The doorbell camera, once a passive device, is now treated as an active accountability mechanism. Officers are reminded that private thresholds are not negotiable spaces. The systemic impact extends beyond training. Municipal insurers adjust risk assessments. City attorneys update litigation forecasts. The cost of constitutional error is recalculated. A single encounter, lasting minutes, has produced consequences measured in millions. The social worker returns to her life outside the public record. Her role in the case is preserved in filings and footage, not in spectacle. She does not need to be elevated. The law has already recognized the intrusion. What remains is the footage. It does not accuse. It does not editorialize. It shows. That is enough. In the aftermath, the case stands as a reminder of how quickly authority can invert when documentation exists. Power does not disappear. It shifts. The camera, fixed and silent, changes the balance. The system adapts not because it wants to, but because the evidence makes denial untenable. This is how accountability now arrives. Quietly, digitally, permanently.